Nearly 30 years after Tupac Shakur was gunned down on the Las Vegas Strip, the only man ever charged with his murder is finally going to trial. Jury selection began today for Duane Keffe D. Davis, with about 75 potential jurors called to court. Now, the process could take several days, and once the jury is seated, this trial could reportedly last as long as 5 weeks. Keefe D is charged with murder with a deadly weapon. And to be clear, prosecutors don't claim he actually pulled the trigger. No, they say he was the shot caller, that he orchestrated it, that he was the one who helped put this whole deadly ambush in motion. And if convicted, he could spend the rest of his life in prison without parole. But here's what makes this case so extraordinary. Some of the most allegedly damning evidence against Keefe D may have come from Keefe D himself. 2019 memoir, Compton street legend. He apparently described being inside the white Cadillac, writing that, quote, one of my guys from the back seat grabbed the Glock. In a 2008 recorded interview with investigators, he apparently described his nephew Orlando Anderson saying he leaned over, rolled down the window, and popped him. 2018 BET interview, Keefe D said, when he pulled up, I was in the front seat. Now, the defense argues these stories were exaggerated, that they were fabricated, that they were all designed to sell books and get attention. They've even questioned whether Keefe D actually wrote the book. See, the problem with that is he once allegedly admitted he was the author in a jailhouse call. Okay, not great for the defense, but is all this bad enough to convict him? Because reportedly, no murder weapon, no car, no surveillance footage of the actual shooting in question. Are you going to have direct eyewitnesses? Maybe, maybe. I want to bring in somebody with a very unique perspective on this case. That's Robert Draskevich, Duane Keffe Davis's former attorney who withdrew from the case in March. Thanks for taking the time. That jailhouse call, problematic?
It is somewhat. But it won't be the first time that a man has lied to a woman. This is a jail phone call, and oftentimes people exaggerate, make up stories, and try and explain the reason why they find themselves in that certain set of circumstances. But obviously, a jury is going to take that into consideration, and that does create a problem for the defense.
Now, you know, it's interesting. I cover a lot of cases, and I hear sometimes people who say things in jail. You could say, listen, rough environment. Maybe they're just saying whatever they need to say to, you know, protect themselves. Like you said, maybe you said whatever he said for a woman. But the multitude of apparent admissions, the argument would be this was all exaggerated, this was all to sell books, this was all to get notoriety. Is the frequency of it going to be too much for a jury?
That's a good question. You know, you've already laid out the profit motive. You know, Keefe D made a lot of money making these admissions. There was a book published. He's made multiple appearances on TV, and he's been paid nearly every time that he's made these statements. I would anticipate the jury relying upon the evidence, and you've pointed out that there's a lack of hard evidence connecting him to this crime.
Well, is there? I mean, other than the alleged admissions, what is the hard evidence against them? I was interviewing Alexandra Kazarian the other day. She said she doesn't see much. You once said, and correct me if I'm wrong, you described the evidence in this case as voluminous. What else will the prosecution present against him besides his apparent statements?
You know, well, during the time that I was representing him, I kept expecting there to be a new witness, you know, some surprise development. The discovery in this case was voluminous. I mean, we've got 364 gigabytes of discovery, well over 20,000 pages. Throughout my review of that evidence, there was nothing putting him there in the car other than his own words. I'm unaware of a single eyewitness that will put him in the car. In fact, I saw in a recent interview, a jail interview, where he's saying that he wasn't even in Las Vegas at the time of the shooting.
But if they can prove that he was there, and they couple it with that interview, which can, by all accounts, probably used against them, that I have to imagine that could be problematic. What about the idea of any gang associations, any gang associates testifying and what his role was, or placing him in Las Vegas, or talking about any beef that he had? What do you think about that?
Well, I mean, that's the state's theory, that he is the shot caller. You know, that's a common theme. But again, the jury's going to need facts. He has to be there, regardless of what he has said. You know, we've talked previously about these ideas of dual personas. I mean, he's taking some poetic license with his tale. People have done it for decades to sell records. I don't really think this case is really any different, absent any real physical proof.
What about Suge Knight? Suge Knight's in prison right now. There's a question of whether or not he'd be called as a witness, whether he'd voluntarily testify. Do you think that he could be a key prosecution witness? Hey, maybe even a defense witness?
You know, that we had discussed the possibility of calling him. He's currently serving a 28-year sentence in San Diego. I know that he has said repeatedly that he wants nothing to do with this case. In fact, I recall reading wherein he said that Orlando Anderson was not the shooter. But outside of that, time will tell, and we'll see through the course of this trial.
I'm going to ask you a very tricky question because I know you're very limited to what you can say, but any chance Keefe D would take the stand? He said a lot. Will this be his opportunity to tell the jury his side of the story in a different way?
It wouldn't surprise me, perhaps, if he did. He likes to talk. He's a very likable gentleman. He's quite witty. Over and over again, he's wanted to tell his story in open court. If he testifies, it wouldn't surprise me.
And we got 30 seconds. Do you think there's a chance he'll be acquitted? And then
I think,
because he's the only one that's ever going to trial, it seems.
And one would expect the jury to hear from him. Through the course of the grand jury, the prosecution read the book that you had referred to, Compton Street Legend. There's going to be a dispute as to whether or not that, in fact, or those, in fact, are his words. There's quotes, the invisible man. Yeah. You read the book, and it's clearly not the way that Keefe D speaks. It wouldn't surprise me if he did testify.
Duane Keffe D. Davis is the only person charged in Tupac Shakur's killing, and his trial began with jury selection on August 10th, 2026 in Las Vegas. He has pleaded not guilty and faces a murder charge alleging he helped orchestrate the 1996 drive-by shooting rather than pulling the trigger himself. Prosecutors say Davis was the shot caller or orchestrator of the attack and that he provided the gun used in the shooting. Davis is accused in Clark County, Nevada, in connection with the September 7, 1996 shooting that left Tupac Shakur dead 6 days later and injured Suge Knight. If convicted, he faces a possible life sentence without parole. A 2008 police interview with Davis was ruled admissible for trial, and his 2019 memoir, Compton Street Legend, is expected to be a central piece of evidence. An important caveat. The case concerns the allegation that Davis organized the killing. He is not formally charged as the gunman.
That we wanted to talk about the jury selection protocol because it is different from how we usually do it.
I got it.
No? Okay. Mr. Davis, my understanding is that Mr. Samp has made you aware that you have the right to have the jury sentence you if they come back on a first-degree murder verdict, and you have decided to waive that right. Is that correct?
That's not.
Okay. So what that means is when I am talking to the jurors, I'm not going to tell them what the potential penalties are for first-degree murder. Additionally, I'm not going to ask them if they can abide by those penalties and come up with a sentencing agreement or sentencing decision. And then at the end of the day, if that is the verdict, it would be me sentencing you on that as well as the enhancement. Is that your understanding of everything that would happen given this waiver?
Enhancement.
Yeah. So in general, the defense would have, the jury would be able to sentence you on the first-degree murder portion. That carries either 20 years to life, or 20 to 50 years, 20 to life, or life without the possibility of parole. In any case, if there's an enhancement, and in this case there are two enhancements, there's both the gang enhancement as well as the deadly weapon enhancement, that is left up to the judge. In this case, if it's a first-degree murder, that has to be an equal and consecutive 20 to life sentence or life without the possibility, 20 to 50 sentence, 20 to life, or life without the possibility of parole. So that would be up to the judge sentencing, no matter what the jury found. I'll give you a moment to consult with Mr. Sand.
I have a question while they're talking. Because you intend to panel in panel 36, is that 8 and 2 instead of 8 and 1?
Yes.
So it's 10 total.
Yeah, so I'll go over that. The general guidelines at this point. once I finish with the canvas.
Thank you, Honor.
Okay, Mr. Davis, do you understand then what we've gone over?
Yes.
Any other questions that I can answer at this time?
All good.
Okay, and you wish to waive your right to have the jury sentence you on the first-degree murder if that is their verdict?
Yes.
Okay, perfect. I will have this stipulation and waiver of penalty phase or penalty hearing filed. That should cut down the potential for how long this trial will last. Previous discussions had been 4 to 5 weeks. Is that still accurate state to qualify the jury for?
Yes.
Hey Reggie, sorry to interrupt, but I want to let our audience know. If you guys are fans of UFC, you definitely want to pay attention to this. So we've linked up with Morgan & Morgan, the official law firm partner of UFC, and they're giving away 2 tickets to U331 in Los Angeles plus $2,000 in travel expenses. The way to enter is to click the link in the description. You can also find the link pinned in the comments below this video. So click the link and take a chance. You can't win if you don't enter. Good luck.
Mr. Sam, do you think that sounds reasonable, or do you
No, yeah,
suggest a longer?
I believe that's reasonable. I do have one concern that's popped up that I wasn't anticipating. I might be asking the court for a day to depose.
A day?
A day to depose Steve Wilson on August 19th. So apparently my office had submitted a deposition subpoena for Mr. Wilson to make an appearance on a separate issue that's not related.
Unrelated to this case, you have a legal matter
Correct,
that
Your
may
Honor.
have to occur.
And that would be on the 19th.
Okay, and let me look.
Now, my concern is, of course, I would have moved it, but the problem is, though, that particular
And it would be in the
issue.
afternoon?
It-
Well, so here's why I'm saying that. I had gone dark on several of my civil days, but I was going every other day so I could keep my civil cases on track.
Yes.
So the 19th, we are starting at 1.
Okay,
So if it's able to be in the morning, let me know. If it's something that has to be in the afternoon, let me know as soon as that happens.
I guess it just depends on how long we talk in that deposition, Your Honor. It might go a little longer. I'm hoping to get it done as quickly as possible. I just want to let the court know that we may get a little chatty in that one. And I'm anticipating that there will be a motion filed by the state anyways on that one to stay that particular deposition date because of some type of privilege that might be asserted. So as a result, I think there might be some technical things. We just
Okay.
have not received any notice so far.
So I guess if that's something that comes up, we can address it as it comes up. I will definitely try to work around your schedule as I can. I understand it's hard to block out an entire month for trial. So just keep us up in the loop.
I will.
And then if possible, do it in the morning, but if not, I completely understand.
It's going to start in the morning. I just don't know if it's going to traipse into the afternoon. Yeah.
Okay, cool. Anything to add on that? Looks like nothing from the state. Let's go over our jury selection protocols real quick, just so I have them on record, then we'll bring our jury in. So this is going to be just sort of a special selection process. We're going to start with a panel for the hardship challenge, the hardship issues, and then for the second half of the hardship challenges, as well as the individual questioning, we're going to move into individual sequester. That's the agreement between the parties, correct?
Yes, Your Honor.
All right. So it sounds like you guys know what's going to happen a little better than I do because you proposed it. So I'm going to sit back and watch, and I've got kind of the idea of what's going to happen there. The alternates in this case, we are going to do 4 alternates given the length of the case. And so we are going to then they're going to be in seats 13, 14, 15, and 16 once in panel. Preempts, like usual, we're going to exercise using the paper pass back and forth method. As we've already discussed, we will be bringing the jurors back for the peremptory challenges. So I anticipate having this full box filled on that day, which will be Thursday at 1 p.m. Do we anticipate once we get into the sequestered voir dire doing cause challenges up here at the bench?
Whatever court's preference.
Let's try to do it that way and see how that works.
Yes,
Okay.
ma'am.
So then after every juror, we'll have everyone approach, say pass or challenge. Okay, perfect. If you exercise all your preempts, you must use one on the alternate chairs. Mr. DiGiacomo brought up a very good point because we have extra peremptory or extra alternates here. You are getting an extra peremptory challenge. So you're going to get 10 total. Your last 2 have to be used on those alternate chairs, okay?
Yes, ma'am.
Waiver of 1 challenge is not a waiver of all. And then like we just talked about, the challenges for cause will be up the bench after each side is finished with their questioning. If it happens earlier, you just don't think this is a suitable person and it becomes very apparent and you just guys want to approach in the middle, let's do it that way. Okay? We don't have as many issues ultimately with other jurors being tainted by answers, so we can do a deeper dive than usual given the individual sequestered nature.
Yes, Your Honor.
So, anything else?
No, Your Honor.
All right, let's bring in the jury.
On the witness controversy, Suge Knight has been listed on the prosecution's witness list, while former death row security chief Reggie Wright Jr. has also been named as a state witness in reporting tied to the trial. Keefe D has publicly suggested Wright was involved in the killing, and some coverage notes Davis has also alleged that death row security was implicated.
One expected prosecution witness is speaking out. Reggie Wright Jr., the former head of security for Death Row Records, is denying claims from Duane Keffe D. Davis that Wright was involved in orchestrating Tupac's killing, and TMZ spoke exclusively with Wright, and Michael Babcock from TMZ joins us now live.
Yeah, and it's really interesting, Tyler, because I wasn't sure as you find out in the weeks and months leading up to this trial that somebody's actually going to be facing potential life in prison for the murder of Tupac. But this was, quite literally 30 years ago that this murder happened in 1996. You don't know what the interest is going to be. People get older, people move on, the case sort of fades out of memory. But it has gotten a ton of attention, and this guy, Reggie Wright Jr., is one of the star witnesses here. But he is not the man accused or has not been charged with the crime here. But the guy who has been accused of the murder and who is facing the first-degree murder charge is actually pointing the finger at Reggie Wright Jr., Tyler. So it's an interesting situation. Now, that's Reggie there that we're looking at, and he is somebody who was at one time a Compton police officer who then became a security executive at Death Row Records, and Keefe, Duane Davis, the man who was facing the murder charge, has said that it's actually Reggie Wright Jr. who was the one who orchestrated the entire murder. Keefe D claims, that's the guy facing the charges, that he had nothing to do with the murder, that he did not shoot Tupac Shakur, certainly did not kill him. So it's a lot of finger pointing going on here. Reggie Wright Jr. says, bottom line, I had nothing to do with Tupac's murder. I am a prosecution witness, but I am not facing any charges. And he says, yeah, it's actually Keefe that was the one responsible.
Suge Knight is the biggest confirmed name on the prosecution's witness list and is described as the only surviving eyewitness to the shooting other than Davis. Reports also say other listed witnesses include Shakur family members, former Las Vegas officials, and people from Davis's and Shakur circles. The Diddy angle is weaker. One report says Diddy is not on the prosecution's witness list despite public speculation around death row and bad boy era rivalries. That means Diddy appears to be part of the broader media narrative, not a verified trial witness in the current court filings. Combs was also never clearly identified in the current reporting as a witness in the trial. One 2026 report said the defense might want him as a witness, but that was framed as a possibility rather than a confirmed witness status. The prosecution's strategy. The state is building its case on decades of evidence, including Davis's own 2008 police interview, which was recently ruled admissible. His 2019 memoir, and various witness statements collected during the 2023 grand jury proceedings. The defense's strategy: Davis's team is expected to challenge the credibility of his past statements, arguing they were exaggerated for profit or fame, and potentially point toward other theories of the crime, including those involving the security details or rivalries of the era, to create reasonable doubt.
All right, let's bring in the jury.
All right, the jury.